called Dr. Megan Woods.
I felt robbed.
You were robbed. Thank you, Mr. Chairman, and I'm sure my colleague Chris Hipkins can pick up his stream of thought in one of his many contributions in this part of the bill throughout the evening. And Mr. Chairman, tonight I want to talk specifically to Clause 2 of the bill around the commencement date that is set down. And as my colleague Chris Hipkins was just talking about, that this is a piece of legislation that is due to come into being 4 months after it receives royal assent. Now, I'm not going to be talking about whether or not the Governor-General will indeed give this bill royal assent, but talk about the significance of this date being 4 months after and what some of the ramifications of that are. Because, Mr. Chairman, what we have is a number of employers in New Zealand who are very aware of the commencement date of this legislation. In fact, they have been waiting and hoping that this bill will come into force, and indeed have been delaying collective bargaining. Specifically, why the commencement date, as stated under Clause 2 of the bill, has been of specific interest to these employers is around what Clauses 7, 8 and 9 does, around the removal of the duty to conclude collective bargaining. So what we have is a large number of employers, or a small number of employers in this country actually, because we don't have a large number of bad employers in this country. What we have is a very bad piece of legislation going through this House in relation to our employment law. So if we look to some examples of individuals where this commencement date in Clause 2 of the bill, where it's going to affect their lives. So if we have a look at Freda So, who works as a community support worker, she's poorly paid, and her union has been trying to negotiate a collective contract for her and her workmates for the past 12 months, and they still have not achieved their collective agreement. The employer has made it known that they do not want a collective agreement on this work site, but is currently obliged to conclude unless there is a valid reason not to. But what we have with the commencement date in Clause 2 of this bill is a complete removal of that right. And this is what this employer has been waiting for, Mr. Chairman. And we can see very much what this commencement date of 4 months after after royal assent is given to this legislation is going to mean to individual workers out there. It is going to mean there won't be a collective agreement because the employer can simply walk away from it because of the provisions that are in 7, 8 and 9 that will come into being after the 4-month commencement date. We also can look to the meat industry, where this is something that a major employer is very aware of when the date of the commencement of this legislation is going to be passed into place. I mean, we've seen in the meat industry in the last couple of years a very long and bitter battles that have been waged around the issues of collective bargaining, and one that a major employer is now waiting to be able to see there. We see that there are work sites where collective bargaining isn't being concluded. In fact, they're refusing to acknowledge the union, the meat workers union, requests to enter into negotiations and bargaining around a collective agreement because they know that this legislation has been sitting waiting on the government books. They're just surprised that the commencement date is going under Clause 2, Mr. Chairman, is going to be a little later than they first thought it would be, of course, because the government hoped to get it through during the last Parliament, but having lost the vote of John Banks wasn't able to. So the commencement date has been pushed out a little further, and it is a good thing too, as my colleague has said. We also saw the duty to conclude collective bargaining around the ports of Auckland, and this being a very key issue in what happened in the ports of Auckland a couple of years ago. If this legislation had been in place at the time, we would have seen a very different outcome of that dispute, and it's a very clear illustration of why it is, Mr. Chairman, that employers are waiting with such bated breath for the 4 months after the commencement of this legislation and this bill entering into our statute book, because under Clauses 7, 8 and 9 we will have a complete shift. So there were many pernicious things in this legislation that will come into be. Thank you, Mr. Farfoy. There are many pernicious things in this legislation that will come into being 4 months after it receives assent. We've talked at length in this House about the removal of the tea break. We've talked about Part 6A and extending that out. But, Mr. Chairman, the removal of the duty to conclude collective bargaining is one of the most fundamental shifts we're seeing in our employment legislation that is going to come into being when this bill is passed into law. And it is something that we absolutely need to be concerned about. And it's those very reasons why my colleague Chris Hipkins, was talking about that this is, Mr. Chairman.
Call the member, Barbara Stewart.
Thank you, Mr.